Hey, what's up? It's Stephen A. Williams, president and founder of the creditrepairshop.com. I want to make this short video to number one, talk about some success here. I admit I don't usually talk enough about this, but whenever we get um, results for our clients, we always like to celebrate that because it shows that hard work does come through. And the first one that I want to talk about is young lady that had a mortgage on her reports. This was a lot of back and forth work. Uh, it took a lot of back and forth to get this done. This was disputing directly with the mortgage or the previous mortgage provider and to get that information removed. A lot of people don't know that if you have a mortgage and they end up doing a foreclosure, that there's certain rules that had happened from 2008 from the housing crisis that happened in 2008, the housing bubble, to where they were not able to put certain information or keep certain information on their credit reports if you requested it. And what I mean by that is that there were certain lenders that did get in trouble, and part of their so-called restitution or no one went to jail, so they had to pay fines, and there were certain things that they agreed on. Well, this is one of the things that they agreed on is not negatively affect individuals' credit in certain situations. And this was one from a company that was involved in some, it looks like it was like one of the offshoot type mortgage places. And it was removed. Sent the letter today, very happy. Um, it takes work. I know that we've been working on this for a little bit of time, but it did happen. The fruits of our labor did show itself on there. Another one here is one that's in the middle. This is one that I love sharing right now because we don't even know the finished outcome on this. This was an individual that took the pro se defense, and if you don't know what that's about, the link is below here. But briefly, that's where if you have a third party debt collector that has purchased a debt and they're trying to sue you either with another lawyer in your area, but it's from a third party debt collector, you can actually have a case of winning those if you respond to the court summons the right way. Not to say 100%, but it's worth doing, especially when you have a chance of winning and you're not just laying down letting them walk all over you. Well, what we did for this client, we wrote the responses to the court summons, and we made a request for the debt validation, which they did not include in the original summons. So they came back, and when he had his court date, they asked for a 60-day. Uh, they needed 60 days to gather more information or to have another hearing in 60 days. And what I'm and they also sent him some information. And what I'm looking at when I'm reviewing their so-called debt validation, what they had was the bill of sale from the bank that they purchased it from on March 4th, 2020, and they stated that it was a charge off. They redacted the amount that they purchased this specific debt for, and then they had someone sign on it. And then they had a bill of sales, Schedule 1 to bill of sales, individual charge off debt account transfer pursuant to the credit card account purchase agreement, and bill of sale described an electronic file name, and then they had the file name, and it showed the number of charge off accounts that they purchased, which was 6,168, and they redacted the total unpaid balance amount and the percentage what I'm estimating is the percentage that they bought, like the amount of what the total unpaid debt was. What was the percentage that they purchased that for? And they sent some statements and stuff like that. What I wrote back to him and stated is that, number one, this is not a full validation, and they're probably trying to get more information about the account, because when you ask for validation of the account, and this is where other people get it wrong when they do validations. I've seen attorneys even do this wrong. Is how are you? Let's just look at it this way. How are you gonna validate an account that has your name on it? Or how are you going to say that the account is not yours when it has your name on it, when you're in court? You know, you're making it easy for them to win their case because you're not actually trying to put forth any real defense on it. What you should do is, number one, if it's purchased by a third party, you need to make sure that that is known by the court, which they usually state that, but you want to make sure that they're aware of it. And then you make sure that they give you this information like they supplied with the bill of sale. Then the next step is to make them validate the entire debt amount, because they're saying that you owe, you know, $3,000. You want to make them show all of the charges, which the original creditor, if you called up the original creditor and said, give me a download of all of my charges, they would have it, you know, either right away or next day, or they send it in the mail within a week. Well, this is something that you should always do when you're dealing with these third-party debt collectors, is you want them to get all of that information to you and provide it so you can verify if the balances are right, all of your payments that you made to them are correct. The interest rate is what you recollected to be, that there wasn't any changes of the interest rate or changes of the terms without you being notified. You can argue all of that type of stuff. And that, you know, the worst case scenario on that is that you just back the debt collection company into doing a discounted settlement. I mean, that's the worst case scenario on the whole thing. Uh, and so with this one right here, they asked for 60 days to for another court date. And if I haven't said it, or just to refresh everyone's memory on what to do if you're in court and a debt collector asks for more time and you have responded with your answers to the court summons, is that you should ask them to dismiss the case. If you've given them ample enough time to respond and get the information that you had in your uh, answers to their court summons, you know, what you also requested, that if you've given them enough time, which I would say a week or two, 2 weeks probably would be the safest, but 1 week is good enough also. If you've given them that amount of time to get everything before court and they come into court without that information, you should ask to have it dismissed because you gave them enough time to get that information to you. Before we close out here, I want to go over another debt batch that's being released into the market. $8.27 million, 3,001 accounts. Average account balance is $2,758. The charge-off dates is a mixed charge-off date, and they're selling the whole account for, I mean, this is less than 4 cents on the dollar for $4,139. So this is way below one penny, considering how many accounts and the total principal amount. Now let's just briefly go over what you should do. Number one, when you get a demand letter from a debt collector who has purchased debt from an original creditor, is you need to immediately go to your the statute of limitations for collecting debt in your state. These are all credit card uh, accounts. So if you go to my website, thecreditrepairshop.com, in the fourth column, it has open accounts. An open account is like a charge account where you can, a credit card account, you can charge, pay it down, charge again. So that's considered an open account. Look at the statute of limitations on that. If it's past the legal statute of limitations to collect in your state, you simply just have to notify the debt collector that you know that they are trying to come after you for a debt that's past the statute of limitations, and you need to tell them to cease all collection activities. I have a letter that you can use below here to get them to stop that. If the debt is not past the legal statute of limitations to collect, then the next step that you want to do is you want to do a debt validation, or you can use my cease and desist collection activities, the debt collection activities letter. Either one of those can work. Use the cease and desist collection activities first, and then if that doesn't work, then you go into the debt validation. And that can stop them before it gets to going to court, or before it gets placed on your credit reports. If you don't respond to that 30-day letter within the 30 days that they ask you to dispute it, they have permission to place that on your credit reports. Because you didn't respond the way that the law is crafted, that means that they have ample uh, proof that you are the individual, and they can place that information, that collection account, on your credit reports. And then you know what happens with that. It starts to take time to get that stuff removed or dealt with. If it's already on your credit reports and they're just sending you letters over and over again to get you to pay it, then you should immediately still look at the statute of limitations, and then you should send the cease and desist collection activities letter and or the debt validation letter. Now, let me tell you how you can have a debt start over. Um, if it was past the legal statute of limitations to collect, and you accidentally paid $1 or $10 or whatever the amount, you would start the time clock over right at that time. So if your debt was going to be over with, and somehow they talked you into making a small payment so you can get them off of your back, that would reset the statute of limitations time frame. So you don't want to do that. You want to be careful when talking to debt collectors and saying that a debt is yours. You want to be careful of making any payments unless you're looking to really follow through on that debt. If something came up where you need to resolve it because of a job or something, then yeah, you might want to take that route. But if it's something where you're just afraid because they made threats to you, don't make any payments. You'll still have enough time to resolve it at a later date, and your job at that point is just to gather as much information and make them prove that they still have legal that they can legally come after you for the debt. So please do that. I see over and over where people got confused, or they got emotional, they got scared, and they ended up paying a debt that they didn't have to, or they didn't go through the full process of a debt validation, or even looking to see if it's past the legal statute of limitations. So get those letters. It's worth getting those letters and at least seeing if that could be a solution, because a lot of these third party debt buyers, they just buy debt and they don't want to go through any trouble to collect them. They just want to go after the easier people to collect those debts. So if you haven't subscribed to my channel, please subscribe right now. I want to get those numbers up. I want to hit 40,000 subscribers this month. And if you need help with your credit, please visit thecreditrepairshop.com. If you need your reports and scores, because everything starts there. That's you need your full credit reports, not from these free companies. You need a full credit report so you can look at the actual date of the charge off, because that's when the clock would be ticking for a statute of limitations, for your statute of limitations argument on not even having to pay the debt. It does not matter when the debt collection company took it over. It matters when they did the original charge off. So this is Stephen A. Williams, president and founder of the creditrepairshop.com. Thank you, and until next time.